Thank you, Mr. Speaker. It's with great conviction that I open the first hour of debate regarding my bill C-475, whose objective is to propel the Privacy Act into the digital age. I'd like to read a quote from the Privacy Commissioner, Jennifer Stoddard, published this morning.
Of meeting the challenges of today, and certainly not those of tomorrow.
So it's no surprise, because this act has not been updated since the first generation of iPods. So things are evolving very quickly in the digital age, and this law is no longer relevant. Many millions of Canadians never knew a world without smart apparatus. This is a reality in our modern society, and constant change is a part of life. The internet is at the heart of our lives because we use it daily. It's not surprising that Quebecers and Canadians will spend about 45 hours a week on the web in 2013. Over 70% of Canadians use the internet daily, and over 18 million Facebook accounts belong to our citizens. Canada is resolutely plugged in. For a few years now, multiple tablets and other smart devices are used for recreation or work and have a more and more critical place in our lives. We are converging toward a management of our lives that is increasingly numeric or digital. This change means that new rules must be put in place. Rules that must take into account the new risks associated with this evolution of the digital world. Since the beginning of this year alone, we have seen serious leaks of data, including the personal information of 52,000 Canadian investors in February, or over 50 million clients of Living Social in April. The Privacy Commissioner recently indicated that attacks on personal information have been increasing constantly in the past few years. In this regard, a study by TELUS and the Rotman School of Business at the University of Toronto published a study in 2011 showing that for every corporation on the stock market, there have been on average 18 attacks on data annually. Unfortunately, the Act, whose mandate it is to protect the privacy of Canadians, has not been updated to counter these risks and to implement appropriate measures in our society. The current legislation does not allow for warning Canadians affected by an attack on their personal data. Organizations have no obligation to warn them, regardless of the severity of the attack. Because of this, our citizens cannot take appropriate measures to safeguard their identity or credit and reduce the damage that they could encounter. I'm referring to SIN numbers, passwords, personal email, or even bank account numbers that are necessary for some online purchasing. Sharing of personal information without consent is also a major problem in Canada. In September 2011, the Privacy Commissioner indicated that 1/4 of websites that are most used in Canada did not respect Canadian law and disclose our data without our consent. This situation is very worrisome to me when I think of children, seniors, and people who have not had an opportunity to really learn how the internet works or what its risks are. What's even worse is that companies that choose to do this currently face absolutely no consequences. For over 10 years now, Canadians have been waiting for better legislation and regulation. With good reason, they're expecting results, and it is in that spirit that I decided to table Bill C-475. The bill puts forward two simple and effective mechanisms to emphasize the protection of private information of Canadians. First of all, C-475 provides that the Privacy Commissioner's Office be warned by organizations when there is an attack on data that could prejudice their users. Commissioner experts will assess the level of seriousness of the situation according to a threshold that is pre-established with high standards, and will recommend whether or not the organization should warn its affected users. This mechanism allows for objective analysis of the risk and not a subjective analysis based on the interests of the organizations, which may differ from those of their users. This process will give citizens the means to take measures to protect themselves much faster and to reduce potential harm. The second mechanism under Bill C-475 is based on the Alberta provincial model. It gives the Privacy Commissioner the power to give orders when an organization does not respect the law. The federal court will have legislative means to punish organizations that are not subjecting themselves to the Commission's orders. These mechanisms are simple and clarify the jurisdiction of the Privacy Commissioner. It will now have the power to have the law respected, which is not the case right now, unfortunately. By providing a better framework for these organizations and the use of private information to which they have access, Bill C-475 gives Canadians the assurance of an acceptable level of risk management and the right to seeing their data protected. At the heart of this bill is a concern with Canadians, stakeholders in the digital industry, organizations that take care of civil liberties, internet experts, and experts in safety and privacy. I've heard many views from experts at the Ethics Committee in the course of a study on social media and privacy from May to December 2012. C-475 responds directly to the demands of the stakeholders in this field by adapting the legislation to the digital age, by preserving some flexibility for the industry, and by clarifying the Commissioner's ombudsman role. Moreover, through multiple specific consultations to discuss the bill, the same conclusions were reached. This bill is therefore a very balanced approach. It's also balanced for Canadians because an objective analysis of risk will ensure that they're not bombarded by warnings about data loss, which doesn't even affect them or whose risk is very minimal. It is also balanced for corporations because the clarity of roles and processes allows them to provide further policies and actions. This will be clear. Organizations will have an obligation to disclose to the Commissioner's office, but they will not be responsible for deciding on the final level of risk. Companies that respect the law will no longer have to compete with those that do not comply. Lastly, this bill brings up our standards on personal data to the same level as Germany, Great Britain, Australia, and France, or even provinces such as Quebec and Alberta. As a world leader in technology, Canada must have international standards.
Bill C-475 has a different vision from the one put forward by my colleagues opposite in this House, who in 2007 tabled Bill C-12, which is no longer supported by the Privacy Commissioner. They will likely say that they have already tabled a bill to modernize the privacy bill, but I'd like to remind them that this bill dates from 2007 and is absolutely not representative of our current era, especially considering that technology evolves at a very swift pace. C-12 was tabled in the House, but no debate was held on it for the past 6 years, and therefore its content is definitely obsolete. Bill C-12, it was not a serious attempt on the government's part to modernize our bills and protect our citizens. Furthermore, one of the problems with one of the C-12 mechanisms shows that it is inadequate. In fact, the risk threshold before advising the Privacy Commissioner is very low and very subjective. This poses two major problems. The first is, because the threshold is low, The users and the commissioner will not be as advised or as aware in the case of a data breach. The organizations will not even have to warn the citizens concerned, and they will not thus be able to protect themselves. The second problem is that the experts who came to testify at the committee explained the importance of obtaining better data in order to better understand the risks of cybersecurity that Canadians face daily. A low and subjective threshold thereby diminishes the quality of this data, and they will not be able to advise the government and businesses as well. My bill creates an objective threshold, and it will be the Commissioner's mandate to evaluate the threats posed by these breaches. Therefore, it is not the interests of businesses that would take precedence, but those of Canadian citizens, and they are the ones we must protect in this House. Quebecers and Canadians support the measures and principles defended by my bill. A study published in April by the Privacy Commissioner, conducted in all regions of the country, showed that 97% of Canadians want to be informed about any data breach with regard to their private information, so we can understand that that is the overwhelming majority, and 80% of them also want to give more powers to the Commissioner's office. So we understand once again that this is an overwhelming of the majority of Canadians who support this measure. Support for my bill comes from all players affected by these changes, including industry, advocacy organizations, specialized law professors, communication and cybercrime professors, consumer protection organizations, and the list goes on. The Union des Consommateurs, and I'm quoting this, Mr. Speaker, considers that the implementation of the principles proposed by the NDP through its bill seeking to amend the Privacy Protection Act and electronic documents would be a true advance to better protect the privacy of consumers.
Law at the University of Ottawa and renowned public affairs pundit has said about my bill that, and I quote, "Bill C-475 is a far better proposal. Those provisions would go far to ensure a greater respect for Canadian privacy law and give Canadians the assure of notifications in the event of security breaches." The executive director of Openmedia.ca, Steve Anderson, stated that we welcome this online privacy bill because we think it's a tool that can later be applied to protect our privacy against reckless, warrantless access to our private information by government authorities. This bill is a useful stepping stone to safeguard our privacy. Et je ferme la citation.
End of quote. The citizens of our country rely on us to act in their best interests. They are clearly calling upon us to better protect them. By voting to support C-475, my colleagues are reassuring them that their rights will be better protected and their privacy as well. Thank you.